Prenuptial agreements, agreements that couples enter before they get married so that in the event of divorce or death, they will know how the property is to be divided. Well, what happens when somebody doesn't feel they are fairly dealt with under a prenuptial agreement and then divorce takes place? That takes us to this week's case. It involves a real couple, South Carolina. And there was a young woman who came from the Ukraine to marry a man here in the United States in South Carolina. She got here, and shortly after getting here, she became pregnant with his child, later her husband's child. And she didn't have any job. She was entirely dependent on him. And she didn't speak English all that well and definitely did not read English. He presented her with a prenuptial agreement that said, this is the way our property will be divided in the event of divorce or death. He never translated it. She didn't have an opportunity to get an attorney because she didn't have any money. She also wasn't that familiar with American culture and certainly not that familiar with the English language. All right, nonetheless, she signed this prenuptial agreement. She signed it 6 weeks before the marriage. Well, the marriage went forward, and the reason we are talking about this case is the marriage didn't go well, and the parties broke up, went their separate ways. He said and argued that the prenuptial agreement that separates property and determines how property will be divided controls. She, through her lawyers, said no, that's not the case because there was undue distress. And she went through those various factors that we've just discussed. When the court heard this, it reviewed these various factors, and actually this case went all the way up to the Supreme Court for South Carolina. And there, the court finally decided once and for all and said, yes, yes, yes. There was undue distress here. Undue distress consisted of the fact that she was without money, she wasn't familiar with the English language, she didn't read the English language, it was never translated, the prenuptial agreement was never translated for her, and she had no opportunity to get an attorney. So in those circumstances, she really had no alternative. She wanted to marry this guy, felt this was her only real way in which to make a go of it, and she signed the agreement. That was undue distress. In view of undue distress, the courts said the agreement is out of here, it doesn't count, it's unenforceable. So once again, we see the kind of things a court will consider when it considers enforceability of a prenuptial agreement. And here we see the concept of undue distress, and we see the kind of factors that lead to undue distress. Another thing that wasn't really fully discussed in this case, but is always important, is there must be a full revelation of all the assets that somebody has. And that has to happen on both sides of the equation. Both the fella and the gal entering into a prenuptial agreement need to say to the other, these are my assets, this is what I own, this is what I control. Because with that information, the person on the other side can make an informed decision. That's very important. Well, we bring you this case, as we bring you cases every week, so you understand how the law works. I'm David Allen.